On this video, we're going to analyze the torts question that was on the July 2004 California bar exam. I hope you have read and analyzed the question already, but I will summarize the facts for you. In this problem, Jack owns the world's largest diamond, worth $1 million uncut and worth $3 million cut. However, it's very difficult to find someone who will cut it. Chip is the only person of the diamond cutters known who is willing to take a shot at cutting this diamond, because if you cut it wrong, it shatters and becomes worthless. If you cut it right, the value goes from 1 million to 3 million. Chip and Jack have a contract in writing in which the deal is Chip is going to cut the diamond and receive $100,000 if Chip is successful and nothing if Chip fails. On the way to cut Jack's diamond, just a few doors away, Chip is crossing the street with a green light when Wilbur ran the red light, driving very slowly, and hit Chip. Caused a gash on Chip's leg, nothing more than that. And a normal person would easily have recovered from that, but Chip was a hemophiliac and bled to death and died. Chip's wife, Melinda, is now suing Wilbur for the harm caused to her by the death of her husband. And Jack cannot get his diamond cut anymore because Chip was the last diamond cutter in the world who was willing to do it. So Jack is also suing Wilbur for $2 million. In the suit, when Jack sued Wilbur, Jack hired a lawyer to do the job. The lawyer failed to bring the suit against Wilbur in time for the statute, so the statute of limitations ran, and now Jack can no longer sue Wilbur because the statute is run, and Jack is suing the lawyer who let the statute run for what Jack would have gained if lawyer had sued Wilbur in time and won. And those are the lawsuits. Lawsuit by Melinda against Wilbur, a lawsuit by Jack against lawyer. Because lawyer let the statute run when lawyer should have sued Wilbur in time. Looking at the first of these suits, Melinda versus Wilbur, her cause of action is for wrongful death. Now, there are two types of, first of all, we all know that at common law, a person's cause of action died with a person. So if you killed somebody, there was no cause of action against the slayer. So at common law, it was cheaper to kill somebody than to injure them. Modernly, every state has a statute which changes the common law. Survival statutes and true statutes are the two types of statutes which courts have. The survival statutes simply say that the causes of action which the defendant had, which the decedent had, at the time of death, will survive the decedent. In a jurisdiction with survival statutes, then you see here that in those jurisdictions, most causes of action will survive. the death of the decedent. That's what the statute does, is to make those causes of action survive. If they do survive, then the decedent may have some tort claims which they can bring. And if the decedent has tort claims, they can collect things like pain and suffering, medical bills, all this sort of thing that happened during the lifetime of the decedent. Any pain and suffering, for example, would have happened during the lifetime of the decedent. Medical bills ran up during the lifetime of the decedent. Other tort claims. So most causes of action will survive, and they belong to the estate of the deceased person. So whoever is representing the estate of the deceased person can now bring these causes of action since they survived. In addition to causes of action surviving, the estate is permitted to recover damages to the estate. How is the estate damaged? Well, the assumption is that if this person had lived, they would have added more money to their estate, and since they died early, the estate which they left is much smaller than it would have been if they had lived. In other words, their earnings less their expenses. And that damage to the estate is then reduced to its present value, and that can be paid to the estate right now. So the estate gets two kinds of recoveries: the damages to the estate for the early death of the decedent, and tort claims which survived. You bring those claims and collect them. You still have to establish that the decedent would have had a tort claim had he lived, and we'll come to that. The second type of wrongful death statute is the true wrongful death statute. In these true wrongful death statutes, the policy is that by statute, the court creates a cause of action that is limited to certain specific relatives. Specific relatives will be named in the statute. These specific relatives which are named in the statute are typically the spouse, parent, child, a few other people, but they're named in the statute, and these are the people who can bring a cause of action under these true wrongful death statutes. Now, please notice, let's back up for a second. What these people who can bring the action can recover is for these kinds of damages. The person bringing the action, a spouse, for example, might bring an action for loss of companionship. Now, please notice that up here, that even if the causes of action survived, that the spouse did not get compensated for the loss of companionship. That's because up here, the person's causes of action that survived, the person had, let's say they lived for 2 weeks, they've got 2 weeks worth of pain and suffering, 2 weeks worth of medical bills, and that goes to the person's estate, and also the damages to the estate, that goes to the person's estate. But the spouse, the surviving spouse, isn't going to have companionship for the rest of his or her life, and they haven't been compensated for that. They're not going to have the services of a friend to help them. People help each other through life. They won't have that person. They haven't been paid for that. The person who died might have received some gifts by inheritance had they lived, and the surviving spouse might have gotten the benefit of those contributions. They won't get that. The support, the economic support that this person would have provided for them during their lifetime. Sure, we paid the estate what the excess that the person would have had left over, put that in the estate, but most people help each other out economically during their lifetime. And so the surviving spouse has not received that. So in these jurisdictions that have true wrongful death statutes, they allow specific people named in the statute to recover for the loss of companionship for the rest of their life. By the way, the presumption is that people will not get remarried. So it doesn't matter, because if you're going to take away the money if people get remarried, it would sort of put a restraint on people's willingness to marry. And so the presumption for the payment here is that people will not remarry. So that person, the surviving spouse, won't have companionship for the rest of their life. And what you do is you try to reduce that to dollars as best you can. The economic support that the surviving spouse would have gotten the rest of their life, reduce that to dollars. The services and the way people help each other, reduce that to dollars. Contributions, as I described a minute ago, reduce those to dollars. And these are the compensations which the specific relatives are entitled to receive. Please notice that the specific relatives do not receive compensation for their sorrow because someone died. Okay? This is all about things that presumably the surviving party, surviving spouse, will have to hire somebody else to do. And that's what's being paid for here. You're not paying for the widow's or the surviving person's sorrow. That's important. So this is how the two systems work. Notice that jurisdictions that have survival statutes may also have true statutes, because they recover two different things. There's survival statutes, causes of action which the decedent had during their lifetime, right up until the moment of death, plus the damages to the estate of the deceased person. And those are very different from the loss of companionship, support, services, and contributions, which the survivor will not have now. And so most jurisdictions allow the survivor to recover for these things. In fact, generally, these two causes of actions are brought together. This one on behalf of the estate, and this is on behalf of whoever is named in the statute. They're usually brought simultaneously. But you see they are recovering different things. So in our case, Melinda is going to sue Wilbur for wrongful death, and if she is in a survival type jurisdiction, then she will, the causes of action which Chip had, the pain and suffering that Chip suffered from being hit by Wilbur, medical bills that Chip had, just those things particularly. So she will sue for those causes of action plus the damages to Chip's estate. Melinda can do that under these survival type statutes. But most jurisdictions will also have true wrongful death statutes, and she will add this suit to it. And in the true wrongful death statutes, Melinda will take the position that I am a spouse, and she's probably one of the people named in the statute, and she will try to collect for these things. So our remaining problem then is whether or not, what causes of action did Chip have? If his causes of action are going to survive, what were they? And let's take a look at that. Chip's estate is suing Wilbur, and of course Melinda is going to be representing Chip's estate. She will sue. The cause of action Wilbur had for negligence will no doubt survive. Wilbur had a duty of due care owed to Chip, and he explained why, because Chip was a foreseeable plaintiff at the intersection. Wilbur breached, used negligence per se. You know the rule that the unexcused violation of an applicable criminal statute is negligence per se. And here we have a criminal statute that says don't run the red lights. Wilbur ran it anyway. This statute that says don't run the lights was intended to protect this type of plaintiff against this type of injury. Therefore, Wilbur has committed negligence per se. That's your breach of duty. Now this breach of duty, we're suing Wilbur. Wilbur's breach of duty must be the actual and proximate cause of damages to Chip. And so Wilbur is suing, and she's saying Chip would have had $100,000 from cutting that diamond had he lived, and we'd like to collect that $100,000. Chip would had pain and suffering that he's entitled to compensate. Chip had medical bills, and finally Chip died. Now, when Melinda sues for the $100,000, she will say, but for the negligence of Wilbur in hitting Chip, Chip would have cut the diamond and earned $100,000. Problem is that even though Chip was willing to take on this very difficult task, and we hope that he would have cut it right, we don't know that. He might have shattered the diamond, in which case Chip would have received nothing. And so this contract that Chip has could result in Chip receiving nothing or receiving $100,000. So you can't really say that but for Wilbur's killing Chip, Chip would have earned $100,000. You don't know which way that would have gone. Even if you change to substantial factor, can you say that the death of Chip was at least a substantial factor in Chip not receiving this $100,000? Well, I don't know. It's pretty speculative, and might not be able to recover that. Pain and suffering, yes, Chip had that. Medical losses, probably. Now, Chip died, and you know that you don't expect people to die from a little gash on the leg. But you and I know you take your plaintiff as you find him, and that will show up on the proximate cause. So the actual or but-for cause, you cannot say that but for Wilbur killing Chip, Chip would have earned $100,000. So there's a fair amount of speculativeness here, and damages must not be speculative. Secondly, pain and suffering. Chip should get his pain and suffering which occurred during Chip's lifetime. Chip should get his medical bills. And finally, Chip died. But for Wilbur's negligence, Chip would not have died. And so the death was caused, that's the wrongful death. The proximate causation, the $100,000 loss occurred in a most unusual way. Most of the time when you hit people with a car and you have an accident, and the person, the people are on their way to work or something, but they're not on their way to a place where they're about to make $100,000 suddenly. And so if they can establish that they're on their way to make that $100,000, now they can't get there, does the negligent party have to pay that $100,000? The answer is probably not. It's probably just too unforeseeable, and the public policy will not extend your liability to events which are too unforeseeable. And although this person apparently was ready to do it, might have earned the $100,000, it's just too unforeseeable, and so the defendant, Wilbur, would not have to pay this $100,000 because it was not be treated as legally caused. The defendant, Wilbur, will pay pain and suffering, will pay medical expenses, and the death, even though it was, you don't foresee that someone would die from a little cut on the leg, that in the case of people, the injury to people, and people die from it, that you take your victim as you find them, and the proximate causation does extend to unexpected consequences when people are personally injured, unexpected medical consequences. But it doesn't extend to unexpected, events that are that remote when we're talking about property damage. So the question then is that if the estate is going to sue Wilbur for damages, what could Wilbur have gotten? And this is what Wilbur could have gotten. Probably could not have gotten $100,000. Pain and suffering, yes. Medical expenses, yes. And the the death was caused, and then so that when you have cause of death, we just went through the damages that you can get for that. Now, the next lawsuit in the problem is Jack versus Lawyer. And you recall that Lawyer was supposed to sue Wilbur and let the statute of limitations run. Well, Lawyer was suing Wilbur because a chip can no longer cut the diamond. Lawyer is suing Wilbur because Chip can no longer cut Jack's diamond. And Jack is saying, I lost $2 million because Chip can't cut my diamond. So in other words, Lawyer was supposed to sue Chip, saying, Chip, you negligently interfered with a contractual relationship between Jack and Chip. Once again, Lawyer was supposed to sue Wilbur, saying, Wilbur, you negligently interfered with the Jack-Chip contract. So Lawyer was supposed to sue Chip, didn't file in time. Lawyer should have sued Chip, saying, Lawyer should have sued Wilbur. Lawyer should have sued Wilbur, saying, Wilbur, you interfered with this contract, and we want you to pay. Well, what you need to know here is that there is no cause of action for negligent interference with contracts of others. So Wilbur negligently interfered with this contract, and there's no cause of action that allows Jack to recover from Wilbur for that. At common law, the action was allowed in the sense that when people had servants, and if someone negligently injured a servant, then the master could say, well, I will be deprived of the services of this servant until they recover. And so pay me, the master, for the services I'm not getting. Well, that went on at common law, and maybe it made some sense back in those days. But those causes of action are dead now. You do not have a cause of action for negligent interference with contracts of others. And so here, that's what happened. Wilbur negligently interfered with this contract, and Jack wants to recover his $2 million loss, because the diamond now will only worth $1 million, and Jack is saying, pay me the $2 million loss. And the answer is no, no such cause of action. So even if Lawyer had brought the cause of action against Wilbur on time, as a matter of law, Jack would have lost. And so if, even though Lawyer let the statute of limitations run, and that is negligence, the lawyer's negligence did not cost Jack anything. We can't say that, but for a lawyer's negligence, Jack would have not been injured. Just isn't true. So we come over then to the final steps of this problem. Jack is suing Lawyer for malpractice. The malpractice requires that Lawyer breached her duty to Wilbur. There's no problem with that. The statute of limitations ran. Secondly, the breach of duty, Lawyer's breach of duty had to be the actual cause of Jack's injury. In other words, but for the lawyer's negligence, Jack would have won the previous lawsuit. And that just isn't true, because Jack would have automatically lost the previous lawsuit. So we can't satisfy the causation. This is why you often hear people saying suits for malpractice require a suit within a suit, because you're not only suing the lawyer for malpractice, but you got to prove that if the lawyer had not malpracticed, that more likely than not, the plaintiff would have won. And here we know the plaintiff would have lost, therefore Jack is going to lose this malpractice suit. So the two requirements for actual cause is this inside lawsuit here, but for a lawyer's negligence, Jack would have won, and that's not true. And the second requirement is that the judgment must be collectible. If you could have gotten a judgment against somebody, but you never would have collected it, then you won't be able to collect from a lawyer who committed malpractice either. Finally, here, just these notes. There is no cause of action for negligent interference with contract. We understand that. And the final comment here is that if you paid Jack $2 million that he's suing for, then Jack still has the diamond, and you pay Jack $2 million and he's got the diamond and $2 million, and he can still try to get somebody else to cut it later on. And that is clearly unjust enrichment. So that's another reason that Jack will not be able to collect his $2 million, because it will result in unjust enrichment. And that is the end of the analysis of this question.